believe that this might create some hiding places for, I mean, it seems like a whole bunch of reasons not to do discovery. You know, you could file a motion to stop people from discovery on either side. Does that seem correct to everybody? Anybody got any input on that? Any opinion or not? Not very talkative, okay. It also codifies a provision at B5B that talks about if you accidentally produce privileged and confidential information, and gives a step-by-step process of what needs to be done to correct an errant production of privileged confidential information. And basically it just says notify the other person, the producing party notifies the receiving party, and then there are a number of things you can do. You can notify the court, produce the documents to the court. The receiving party produces the documents to the court for the court's in-camera inspection. In 3230, regarding depositions, the way I've always done, if I wanted to video a deposition or do anything other than use just a court reporter, is just call the other lawyer and ask them if they objected, and then send them an email or a letter confirming whether or not they objected. If they object, obviously, then you had to, typically we would have to get the court's permission, which was very rarely was that a problem, because the statute was that it was freely granted to video the deposition. This says that you can just notice it or counter notice it, either party, the party demanding the deposition or the other party. The 3233 talks about interrogatories, and it specifically adds electronically stored information. That was the main revision. 3234 is request for production of documents. It also talks about electronically stored information, and pretty much all of the revisions in 3234 pertain to electronically stored information. It talks about more specific description of the documents that you're seeking. 3237 G, again, something interesting to me. It seems like it says, absent exceptional circumstances, it removes the imposition of sanctions on a party for electronically stored information lost as a result of the routine good faith operation of electronic system. It seems like to me that that basically gives a standard for record retention policies that says that if you can write down in a book somewhere that we get rid of information in 3 days instead of 6 months, then we get to do it, and we don't get sanctioned for it, which, again, there's a spoliation instruction that is helpful many times when documents are lost or destroyed earlier than they're supposed to. Of course, my opinion isn't biased at all, so very even-keeled on this, but it seems to me that it creates a situation where a crafty person could write a retention policy that didn't keep documents around very long at all. The next items are the workers' comp items. And the folks that do work comp, when do the changes occur with the judges, or have they already occurred? It's changing the judges from 10 to 8, 5 in Oklahoma City and 3 in Tulsa. Alan, do you know the answer to that? I mean, I knew there were some that there was an appointment or an election process, and some were not reappointed. So they'll probably just rotate off as their terms expire. It sets up the process of the appointment, and it adds with the advice and consent of the Senate. And then the process, if the governor does not make the appointment, or actually if the Senate does not give advice and consent of the appointment, then the governor has 90 days. After 90 days, the governor may select from the two nominees. 85 OS 3, there are many, many changes in the definitions. The most, I guess, practical ones were the change in the definition of a major cause. It changes it from a predominant part of the injury to more than 50% of the resulting injury. What's the practical effect of that to people who do work comp? I mean, will a lot more claims not get accepted as claims in work comp, or?
You can have a position where you have doctors now taking an educated guess as to the percentage. So it's still going to be the same thing.
Right. So it just puts different words in the medical reports, or? Yeah. Okay. The other part was it says that it prohibits consideration of complaints of pain. It seems like to me that would pretty much be the same thing, right? I mean, obviously when you take a history from a patient, they're talking about how much they hurt and where they hurt. That's part of what the doctor starts out with. So.
What they're getting at there is now doctors are required to state more than just a subjective complaint of pain. There has to be an objective finding. There was language years ago that there has to be an objective finding of changes or injury or what have you. Now they've gone back to that.
Let's see. There are many other, and that was kind of my guess, that would just be some new standards that would have to be taught to the doctors and probably the lawyers of how to document their file, so to speak. But it seemed to make a lot of the definitions more consistent with kind of the Civil Discovery Code in Title 12, and also some of the case law with some of these on 26 through 32 changed some of the definitions of evidence-based and that sort of stuff, along with some of the wording in Daubert type situations where they used evidence-based and literature supported, that sort of thing. The 85 OS 11 talks about exceptions to compensable injuries, and talks about it specifically defines what would be considered in the course of employment, when employment commences and when it terminates. In Section 12, there's for about the past 3 or 4 years, I don't have the Ouija instruction down on it, but there's been an exception to the exclusive remedy provision of the Workers' Comp Act with on-the-job injuries, and the revisions in this Section 12 pretty much eliminate that. It was called an intentional tort, and of course when you read the revisions, it makes this exception in a civil lawsuit much less likely. Basically, before you had to prove with substantial certainty that the employer was aware that an injury would occur, and now it defines an intentional tort, and it specifically says that the proof that the employer had knowledge that the injury was substantially certain shall not constitute an intentional tort. So I'm not sure exactly what would fit the exception now, other than having a couple of witnesses seeing the employer go, do something intentional to the. I'm not sure what would fit. It makes getting out of the exclusive remedy of the Work Comp Act much less likely. I guess, which overall is probably a good thing. Section 14 seems also to me, in A2, it allows the employer to